You could wake up tomorrow and realize you are out of status, accruing unlawful presence, and walking straight into a future visa denial that follows you for years. If you ignore this update, you can lose your legal stay in the United States, lose your ability to change to a new visa inside the US, and even damage your green card path. One wrong day on the calendar can trigger a chain reaction: status violation, denial of the next H-1B, consular problems, and travel risk that can trap you outside the US when you try to come back. And here is the part people miss. The 60-day grace period is not a right you can demand. It is discretionary. That means USCIS can shorten it. USCIS can eliminate it in your case. And USCIS can decide you did not qualify because they believe you were not truly in valid status when the job ended. The result is the same. You thought you were protected, but you were not, and now the clock is running against you. The actual regulation says DHS may eliminate or shorten the 60-day period as a matter of discretion. That single sentence is why this topic is exploding right now. In a moment, I will explain the one timing mistake that makes people think they are inside the grace period when USCIS may see them as already out of status. First, let's kill the rumor and focus on the real danger. The 60-day grace period did not vanish from the law overnight. The rule is still in the federal regulations at 8 CFR 214.1 L2. It covers E1, E2, E3, H1B, H1B1, L1, O1, and TN workers plus dependents. It says you are not considered to have failed to maintain status solely because your employment stopped for up to 60 consecutive days or until the end of your authorized validity period, whichever is shorter, once during each authorized validity period. So why are people panicking? Because USCIS has been moving and archiving guidance pages, and people confuse a web page changed with the rule ended. But the practical bad news is still real. USCIS is crystal clear that the grace period is up to 60 days, not guaranteed 60 days, and not longer than your I-94 or petition validity end date. And if you do nothing in time, you may need to depart. USCIS says if you take no action within the grace period, you and your dependents may need to depart within 60 days, or when the authorized validity ends, whichever is shorter. Stay with me, because next I'm going to explain exactly when the 60 days starts counting, and why severance pay can create a deadly false sense of safety. Here is what the 60-day grace period actually is. It is a temporary buffer after the cessation of employment. It is designed to give you time to take a protective action. Protective action means a real filing or a real petition step, not "I am interviewing," not "my recruiter is working on it," not "my manager said they will delay the termination," and not "I still have a paycheck coming." The regulation talks about cessation of the employment on which your classification was based. That is the core trigger. Now listen carefully. When does it start? It starts when your employment stops. That is usually your termination date or last day of work, depending on the employer's documents and what is true in real life. If you are not working, and you are not in authorized leave that still counts as valid employment under your situation, you are playing with fire. Many people wrongly count from the last payroll date. That is not what the rule says. USCIS cares about whether you were employed in the H-1B terms, not whether money hit your bank account. And here is the second trap. The grace period is up to 60 consecutive days, or until the end of the authorized validity period, whichever is shorter. That means if your I-94 or your H-1B approval ends in 20 days, you do not get 60, you get 20. If it ends in 5 days, you get 5. The grace period never extends beyond your authorized validity end date. If you want to stay safe in the United States, subscribe right now. Now we need to talk about what happens if you cross the 60 days, or if USCIS decides your grace period is shorter. Crossing the deadline can put you out of status. Being out of status is not the same as unlawful presence, but it can lead directly to it, and it can destroy options inside the US like changing status, extending stay, and smoothly transferring employers. Unlawful presence is the phrase that creates re-entry bans. USCIS explains that unlawful presence is time in the US without being admitted or paroled, or time after your period of stay authorized expires. For most people with a date certain I-94, unlawful presence typically starts after the date on the I-94 if you stay past it, unless an exception applies. Here is the brutal part. If you accrue more than 180 days but less than 1 year of unlawful presence during a single stay, then you leave, and you seek admission again within 3 years, you can be inadmissible under the 3-year bar. If you accrue 1 year or more of unlawful presence, then you leave or are removed, and you seek admission again within 10 years, you can be inadmissible under the 10-year bar. USCIS states the 3-year and 10-year periods start when you leave the United States. In a moment, I will explain how one late filing can cause unlawful presence to start the day after a denial, even if you thought filing stopped the clock. So how does USCIS check status violations? They check the evidence. They check filings. They check whether you were maintaining the terms of the status before the new request was filed. The regulations even list examples of evidence for maintenance of status, like pay stubs, W-2s, tax returns, contracts, and work orders when requesting certain benefits. If your employment ended and you cannot show you maintain status, your next filing can be denied or complicated. Also, employers have their own compliance systems. I-9 rules, payroll records, and petition timelines can expose gaps. And if the employer withdraws the petition, that is another record point. Do not assume nobody will notice. USCIS can request evidence. USCIS can connect dates across documents. Now let's get extremely specific about employer withdrawal and payroll stopping, because this is where many H-1B holders get trapped. When you are terminated, your employer often withdraws the H-1B petition with USCIS. That is normal. But the timing is not always immediate. Some employers delay, some do it quickly. You cannot control their timing. What you can control is your protective action. USCIS's guidance for terminated non-immigrant workers is built around what you file and when you file it, not on your employer's internal timeline. Payroll stopping is also not the same as lawful status. If you are not being paid because you are terminated, that is consistent with termination. If you are not being paid but still employed, that can be a separate risk area. But the key message is simple. Do not use your pay date as your grace period start date. Use the true end of employment. Stay with me because next I'm going to lay out the exact options you have during the grace period and which ones protect you faster. Option 1 is the H-1B transfer, also called H-1B portability or change of employer petition. If you find a new employer, they can file a new Form I-129 for you. USCIS states that eligible H-1B non-immigrants may begin working for a new employer as soon as the employer properly files a non-frivolous H-1B petition without waiting for approval, as long as key conditions are met. This is one of the fastest survival moves if you can get an offer quickly. Even the USCIS Employer Handbook explains that an H-1B employee changing employers may begin working for the new employer as soon as the employer files Form I-129, but the employer must do it before the employee's period of authorized stay expires. Source. That phrase matters. Before your period of authorized stay expires. If your I-94 is about to end, you may have less time than you think. Option 2 is change of status to B2. This is the I need time to wrap up and search move. USCIS says terminated workers may use the up to 60-day grace period to timely file an application to change to another non-immigrant status, such as B2 visitor. But listen carefully. B2 does not give you work authorization. It buys time to stay legally while you prepare to leave or find a new status path. Here is where timing gets intense. USCIS states that the timely filing of a non-frivolous change of status application will toll, meaning stop, the accrual of unlawful presence until the application is adjudicated. They give a direct example. If you file a non-frivolous change of status before the end of the 60-day grace period, you will not accrue unlawful presence while it remains pending, even after the 60 days passes. But if the application is denied, USCIS says you start accruing unlawful presence the day after the denial decision. That is the denial trap. Most H-1B workers do not know this next rule. A pending change of status does not give you lawful status. It can place you in a period of authorized stay, which is different from being in status. USCIS explains this difference in its H-1B FAQs when discussing pending applications. If the filing is timely and non-frivolous, you may be allowed to stay while it is pending, but you are not magically in a new status until approval. Option 3 is change of status to F1 student. Some people use this as a longer-term bridge, but it is not instant. It requires school, SCIS, and compliance, and you must be careful about timing, intent, and gaps. This can work for certain people, but it is not a quick fix. Option 4 is change to dependent status. If your spouse has H-1B, L1, E status, you may be able to change to H-4, L2, E dependent, and in some cases there may be work authorization rules. USCIS notes dependent status changes as a possible path for some workers. Option 5 is adjustment of status if you are eligible. If your priority date is current and you can file Form I-485, that can change everything. USCIS says filing for adjustment of status is one of the actions that, if done within the up to 60-day grace period, can allow your period of authorized stay to exceed 60 days. Now press like right now so other immigrants see this warning before their 60 days runs out. Now I'm going to explain the bad news hidden inside the phrase, once during each authorized validity period. The grace period is not a permanent safety net you can use again and again without limits. The regulation says, once during each authorized validity period. That means if you already used it during that H-1B validity window, you should not assume you can automatically get it again without risk. Here is another overlooked danger. The 60-day grace period does not authorize work. The regulation says, unless otherwise authorized, the alien may not work during the 60-day period. If you keep working, or do side work, or accept payment in ways that count as employment, you can create an unauthorized employment problem that can harm future immigration benefits. Now let's talk about premium processing, because speed is survival. If your new employer can file the H-1B transfer with premium processing, you can reduce uncertainty and risk. USCIS itself points out that some petitions may be eligible for premium processing for an additional fee. But here's the retention warning. Premium processing does not forgive a late filing. It does not fix an expired I-94. It does not erase unauthorized employment. It only speeds up USCIS's decision on eligible filings. Now let's connect all of this to travel and your future green card path. If you violate status, you can trigger more than one type of future damage. First, USCIS can deny extensions or changes of status if you failed to maintain the previously accorded status, unless USCIS excuses a late filing in its discretion under narrow conditions like extraordinary circumstances. That is not guaranteed. That is a gamble with your life in the U.S. Source. Second, if you leave the U.S. after accruing enough unlawful presence, the re-entry bars can block you for 3 years or 10 years, as USCIS explains. People think, I'll just leave and come back on a new visa. If you trigger the bar, you may not come back at all, unless you qualify for a waiver, and waivers are not easy. Third, future consular officers and USCIS adjudicators can see your history. They can ask, did you maintain status? Did you depart on time? Did you follow the rules? If the record shows you overstayed your authorized stay, that can impact visa stamping and admissions decisions. In a moment, I'm going to give you a simple day-by-day survival plan for the next 7 days, because waiting until day 59 is how people lose everything. Day 1 is documentation. Get your termination letter. Get the official last day of employment. Get your last pay stub. Get your I-94 record and check the expiration date. Your I-94 date is a major line in the sand for unlawful presence in many cases. USCIS explains that unlawful presence typically starts after the date noted on Form I-94 for those admitted to a date certain. Source. Day 2 is action choice. Decide which protective filing you can realistically complete inside the grace period. H-1B transfer filing by a new employer is the strongest path if you can land an offer. USCIS says you may start work as soon as a properly filed non-frivolous petition is filed, under portability rules. Day 3 is filing preparation. If you cannot secure a new employer fast, consider whether a change of status filing makes sense as a bridge. USCIS says timely filing a non-frivolous change of status can stop unlawful presence from accruing while it is pending, but denial restarts the danger the day after denial. Source: Day 4 is avoid illegal work. Remember, the grace period does not authorize work, and a pending change of status does not authorize work in the new category. Do not consult quietly. Do not accept payment. Do not create a violation that will show up later. Day 5 is plan for departure if needed. This is not weakness. This is protection. Leaving before your authorized stay ends can prevent unlawful presence from reaching bar triggering levels. USCIS is clear that the 3-year and 10-year bars are tied to unlawful presence, and then leaving and seeking admission again. Day 6 is communicate with the new employer about start dates and filing strategy. If they will file, push for speed. If eligible, push premium processing. USCIS notes premium processing availability for some filings. Source: Day 7 is stop guessing and confirm your timeline. Count 60 consecutive calendar days from the real cessation of employment, not the paycheck date, and compare it to your I-94 or petition validity end date, because whichever is shorter controls. Now I want to address one more fear that is spreading. If my employer withdraws my H-1B, I'm instantly illegal. Instant is not the right way to think about it. Your status is tied to the rules and your authorized stay period. But cessation of employment is a real trigger for the grace period, and if you do nothing, you may have to depart. USCIS focuses on what you do within the grace period. File change of status, file adjustment if eligible, file a compelling circumstances EAD if eligible, or become the beneficiary of a non-frivolous change of employer petition. And here is the final retention warning. USCIS says you may be able to remain in a period of authorized stay if you take action within the up to 60-day grace period, and that can exceed 60 days if you properly file within the grace period and the case is pending. That is exactly why the deadline is life or death. The filing must happen in time, not the offer, not the interview, the filing. Source: So is the 60-day grace period ended? The legal rule is still there, but the protection can effectively end for you personally if USCIS shortens it as a matter of discretion, if your authorized validity ends sooner than 60 days, if you miscount the start date, or if you wait and fail to file on time. That is the real breaking news. The danger is not a headline. The danger is your calendar. Do you think this rule is fair to skilled immigrants who followed every law, paid every tax, and still get forced into a 60-day countdown after a layoff? Comment yes or no.